for leave to appeal. We haven't said that's what we intend to do. And that's not what is serving before my lady, at least today. What is before my lady is, as we understand it, we put in a request from a lady to clarify the factual findings that she would have made in coming to the conclusion that she came to.
Why?
The reason, my lady, is that upon reading the judgment,
why do you want clarification?
we want
to do what?
We want the clarification so that we may ask the court to reserve questions of law. But that's something that we intend to do once we have received the clarification that we seek from the court. And then what we saw was an opposition to that request. Again, we find it important to place it on record that, but for what my lady stated earlier, that to give effect to the right to a hearing, the audi adem patem rule, the rights of the accused persons in the matter that served before my lady are not engaged, because we're not suggesting that my lady should alter the judgment. The judgment stands. My lady is not going to alter her own judgment. That procedure is simply unavailable. But in order for the state to ask my lady to reserve questions of law, the state has to know what are the factual findings that my lady made in the trial that served before her. And we are not alone in this suggestion. The SCA says this is what is available to you, the state, if it is not clear to you what the factual findings are. We've referred in our heads of argument to two judgments of the Supreme Court of Appeal. The Skuman judgment is one judgment, but there's another that we make reference to. I think it's in footnote number 5 of our heads of argument. It is the Director of Public Prosecutions it is the Director of Public Prosecutions Limpopo versus Lusaba Lucas Malope and another. And that judgment of the SCA, in fact, endorses the approach that was adopted in the Skuman judgment. You see that, my lady, in that judgment in paragraphs, if you read from paragraph number 9 to paragraph number 12 of that judgment. So it is important.
What does it say?
May I just start from paragraph number 9? Justice Kacharia says, before the hearing of the parties were invited to submit supplementary heads of argument in the light of this court's recent judgment in DPP Western Cape versus Skuman. There, the court reiterated the rule that before a question of law is reserved under this section, 3 requisites must be met. First, the question must be framed accurately, leaving no doubt what the legal point is. Secondly, the facts upon which the point hinges must be clear. And thirdly, these facts should be set out fully in the record together with the question of law. Unless the state does this, the court continues, it may not be possible for an appeal court to establish with certainty what the conclusions made by the trial court on the legal point were. So, when it is unclear from the judgment of the trial court what its findings of fact are, it is necessary for the state to request it to clarify its findings. If this is not done, the point of law is not properly reserved. And then he says in paragraph number 11, it is apparent that this injunction was not met. Leaving aside for the moment whether the question posed raised a proper question of law, the facts upon which the point of law was said to hinge were not set out in the state's application. What the state did was to summarize the evidence that was led without setting out the trial court's factual findings. It must be pointed out that the trial court's judgment in the discharge application is not a matter of clarity. If this was the reason the state was unable to set out the facts, it should have asked the trial court to clarify its findings of fact. It did not do that.
Now, do I understand you correctly that you want me to clarify the facts to enable you to find a question of law, a mistaken law that you can appeal? Because that is what it sounds like.
We have a particular view of the of the judgment. But we are loath of asking the court to reserve questions of law in circumstances where we are not certain about the factual findings. Hence the request for the court to clarify what those factual findings are.
So you first want to find clarity on the facts and then look for the point of law.
We will satisfy ourselves whether what we have in mind is in fact sustainable on the basis of the factual findings that we ask Malady to clarify. To do it the other way around, to simply request Malady to reserve questions of law in circumstances where we are not clear about the factual findings, would be to do exactly what the Schoeman judgment says must not be done. What the judgment of the SA in the Limpopo matter I've just referred to says must not be done.
Doesn't the Schoeman judgment say that when a question of law has been reserved, and it is not clear from the judgment on which facts the court relied to reach that legal finding, then it must be clarified. That is what the Schoeman judgment says.
That's what it says, yes.
Yes.
So it says exactly what I'm submitting, that the starting point.
No, it doesn't say what you suggest.
Let me make the submission. The starting point is to know what the factual findings are.
According to the judgment.
Yes, yes. And the state made the request that we made, because on reading the judgment, we don't know what the factual findings are. And I say that with respect. On reading the judgment, we don't know what the factual findings are, hence the request. If it was clear to the state, and in fact on this point we are not alone, because on reading the defense has of argument, they say exactly what you say. In fact, they take it further. They say you were not duty bound to make findings of fact because of what they say is how the state handled the matter. But so it is not only on the state that the factual findings of the court are. It is not clear to the defense as well on the reading of their heads of argument.
So you want me to amplify my findings of fact?
My lady, I take it a bit higher than that. I'm not suggesting that my lady should amplify her findings of fact. In our submissions, we don't see those findings of fact in the judgment itself.
Then how can I now give you findings of fact that you say aren't there?
Well, my lady sat in the matter and presided over the trial, and evidence was left before my lady. My lady would have made certain conclusions of fact on what served before her, and that's what we request my lady to give to us.
Do you want me to now make conclusions on the evidence that was laid that's not contained in the judgment?
We wish to accept that my lady made conclusions, because evidence was laid before my lady.
But made conclusions, but that's not in the judgment.
We don't see those conclusions of fact in the judgment.
So you want me to make those conclusions, although it is not contained in the judgment?
That's what the jurisprudence of the SA.
So you want me to supplement my judgment?
We want my lady to provide to us findings of fact. And we say, the SA says we can make this request to my lady, and that's the request that we're making. We don't expect my lady to render, for instance, a judgment in the sense of an outcome that would be appealable out of this process. The CPA doesn't contemplate that. The judgments that we rely on from the Supreme Court of Appeal also do not contemplate that. They contemplate where you are not clear about what the factual findings are. You make a request and the court makes those available. And they tell us what would be the potential consequences in circumstances where that is not done. So we implore my lady to consider especially the two judgments, the Schoeman judgment and the Limpopo decision, especially the judgment that was penned by Mr. Justice Kachale. In simple terms, what we say is we've read the judgment, so has the defense. it is not clear from the judgment what my lady's factual findings are. On that basis, so that we may determine whether there are proper questions of law that we may ask my lady to reserve based on factual findings that are clear, we made the request.
I can ask you at this stage, what do you say about the defense's argument that I'm Omotoso here, although I am here due to the application that was brought?
Well, my lady is not Omotoso in the provision of factual findings. She has not previously made those available. The defense themselves say it in their heads of argument. They say you could not. You are not Omotoso in providing factual findings that you made. You are definitely not. We have not, nobody has previously made that request to you, and you either decided to say yes or no to it. So the argument about being Omotoso simply doesn't take off the ground. But there's a further point to it. We're not asking you to alter your judgment, in which event the Omotoso argument would fly. It simply doesn't take off the ground. Because we're not saying revisit your judgment, in which event the outcome may be that my lady finds one or two of the accused persons that came before her guilty. That's not what we're looking for. We live with the determination that my lady made. We live with that determination. It's there. We can't run away from it. But what we want to do with it is a different issue altogether. But whatever we want to do with it is indelibly linked to us getting the factual findings that were requested.
Okay.
Thank you, Madam Secretary.
Mr. Gavin?
Thank you, Melody. I have filed comprehensive argument in this matter. I'm not going to repeat everything I have said in my argument today. But if I might just summarize the main points that I make in my argument, Melody. Your Ladyship would have noticed that my heads were filed before the applicant's heads, and without me having had sight of the applicant's heads. And the reason for that is that the applicant's heads were filed out of time. They were not filed within the agreed time period of 10 court days before this hearing. And to a certain extent, the respondents have been prejudiced. No apology has been tendered for the late filing of these, and there's no application for the condemnation of the late filing of these. But I won't take the court from Lady. I am in a position to proceed with my argument. Lady, this court is certainly Omotoso. There can be no doubt about it. Your Ladyship delivered a final judgment in the matter on the 2nd of April 2025. That judgment is final. You discharged your function and cannot now supplement, elaborate or revisit your factual findings. That is the principle in the Firestone case which I referred to in my heads of argument. My lady, there is simply no legal mechanism for this request that has been placed before the court. The Criminal Procedure Act contains no provision, express or implied, allowing the state to request clarification of factual findings after an acquittal. The only possible mechanism would be Section 319 of the Criminal Procedure Act, which the state has not invoked. There is no application to reserve a question of law, and only today has the state stated an intention to do so. Even if they did now file such an application, it would be well out of time. Lady, the authorities relied upon by the state, in fact, work against them. In all the cases referred to by my learned friends, the court makes it clear that factual clarification can only occur if and only if it is ancillary to a properly reserved legal question. The other state is attempting to reverse engineer a factual foundation in the hope that it might later justify an appeal. And that is precisely what my learned friend has in effect told your ladyship the state wants to do. It wants to reverse engineer a factual foundation in the hope that it might later justify an application for the reservation of a question of law. that is procedurally impermissible. The lady then, although I mention in my heads and submit to your ladyship that this application is fatally defective and should be ruled as such, and that your ladyship should not even entertain the application, I will make some submissions on the merits of this application. Lady, if you look at the request that has been made, it's not even a proper application. It's not supported by any affidavit suggesting that your ladyship's judgment is unclear or ambiguous in any way. It's a broad request for the provision of factual findings and clarification. It doesn't, there's no allegation in that request that your ladyship's judgment is unclear in any way, or that it requires clarification, or that your ladyship did not make factual findings. That has been raised for the first time here in argument, and that's impermissible. The applicants or the applicant ought to have filed a proper application setting out why you are now required to provide factual findings and clarification. It failed to do so, and the request or the application is fatally defective and cannot be entertained. Even today, in argument, my learned friend failed to point out any aspect of your ladyship's judgment that requires clarification. The judgment is not ambiguous and simply does not require clarification. It is long, reasoned and careful. It explicitly applies the in dubio pro reo principle. The court made no positive findings of fact in relation to the allegations in the charge sheet because it found that the state failed to discharge its burden of proving those allegations beyond a reasonable doubt. So that is the effect of your ladyship's judgment. You found that the state had failed to prove beyond a reasonable doubt that the allegations in the charges beyond a reasonable doubt. Now my learned friend is asking you to make different factual findings in that regard. Is he asking you to now find that those allegations were proved? That is the effect of what he is asking for. The state's contention that it requires clarification of factual findings before it can identify questions of law to reserve under Section 319 of the Criminal Procedure Act is legally untenable. The trial court's judgment acquitted the accused on the express basis that the state failed to prove its case beyond a reasonable doubt. This means that the factual allegations underlying the charges were not established, and the court declined to make any adverse factual findings against the accused. In law, a question of law under Section 319 must arise on the trial, that is, from the court's actual findings of fact. It cannot be reserved on the basis of what the state wishes the court had found. The state has no right of appeal against findings of fact, and any legal question must be determined on the factual findings as recorded by the trial court. The request for clarification is therefore not only procedurally irregular and incompetent, but also misconceived in principle. It amounts to an impermissible attempt to reopen the trial, re-litigate the facts, and circumvent the acquittal under the guise of seeking clarity. This is precisely what the doctrine of factus officio and the principle of finality in criminal litigation are designed to prevent. The court is not permitted to revise or amplify its judgment to assist the state in constructing a basis for an appeal. The request is overbroad, vague and abusive, with due respect, my lady. The state wants clarification on all factual findings, including on counts where no evidence was led, and Section 174 discharges occurred with the state's concurrence. There's no notice, proper notice of a motion, no affidavit, no procedural footing at all for this application. This is not a proper application. It is a retrospective fishing expedition, with due respect, my lady. That is all it is. My lady, then, there is no list before the court at this stage. There's no list whatsoever between the state and the accused. The case has been finalized. That is the position of the case at the moment. It has been finalized. No application for leave to appeal or the reservation of a question of law has been made, and any such application is in any event way out of time. In terms of the Criminal Procedure Act, such an application had to be brought within a reasonable time. A reasonable time in the circumstances would be 21 days. It is now more than 90 days after judgment was delivered in this case. So, not only is there no application for the reservation of a question of law before you, but the time for bringing such an application has passed, and there would have to be an application for condonation brought. And it remains to be seen if such an application is brought, whether it will be granted. So there is no list before the court. There is no need for your ladyship to furnish further reasons or to clarify your judgment. It would serve no purpose, and this request is an abuse of process. It's an attempt to get your ladyship to revise your judgment, and it is simply unheard of for such an application to be brought. My learned friend has referred your ladyship to no authority for the bringing of such an application in the absence of an application for the reservation of question of law. All the cases he refers to referred to instances where there was a pending application for a reservation of a question of law, which is not the case here. So in short, my lady, the court is functus officio. There is no statutory or other mechanism for this application. The relevant case law does not assist the state. It bars this request. The judgment is clear and the request is procedurally irregular. The application is fatally defective, and there is no ambiguity and no basis to entertain it. If your ladyship will just give me a moment, I just want to look at the points raised by my learned friend to see if I've covered them. He said the following, my lady. We are loath to ask for a reservation of a question of a law without knowing the facts. We want to satisfy ourselves that the questions of law are sustainable. So there he conceded that he doesn't even know whether there are sustainable questions of law which may be reserved. The starting point is to know what the factual findings are. On reading the judgment, we don't know what the factual findings are. So if that is the case, why is there no affidavit before your ladyship to say so? That's not even alleged in the application that is before you, that the state does not know what the factual findings are. And then he says, well, the defense even says that he doesn't know what the factual findings are. Of course I know what the factual findings are. All I say in my head is that your ladyship found that the allegations in the charges were not proved beyond a reasonable doubt, and accordingly you found that those factual allegations were not proved, and that is quite correct. We accept, this is what he said, we accept that you made conclusions we don't see in the judgment. We want you to provide findings of fact. It is not clear what the findings of fact are. We are not asking you to alter your judgment. My lady, if this type of application were entertained, it would mean that an accused person would never know whether the judgment is final, because any court, any judge or magistrate would be entitled to amplify the judgment. There would be no finality. And with due respect, in all the circumstances, my lady, this application force is legally untenable. It's a fishing expedition, and I ask you to dismiss the application. Those are my submissions. Thank you.
Okay, just a brief reply. Our colleague tells you that there is now not a lease between the state and...
Can you just repeat that, please?
My colleague tells you, submits, that there is no lease between the state and the defense, and he's correct. There's no lease. This is a request for factual findings. It is not it doesn't engage the parties into one or the other form of dispute. The request, as I said in my main submissions, doesn't seek to have you alter the judgment. The judgment is what it is. We remain with the outcome that my lady made the finding, acquitted the accused, and we live with that. There is no lease between the state and the defense. The request is directed to the court to provide factual findings, and that's it. And then it was submitted that if this application were to be entertained, then accused persons would not know that their cases have become finalized or not. Again, that's a mistake. It presupposes that in all judgments, it would not be clear to the state what the factual findings are. This procedure is available only in circumstances where it is not clear to the state from the reading of the judgment what the factual findings are. So it is not a procedure that would be available. Schoeman doesn't say that, or the Limpopo judgment. They don't say that in every judgment, this is what should happen. It only happens where there is no clarity as to what the factual findings are. Then it was submitted that this should have come in the form of a notice of motion supported by an affidavit. And this submission comes from a party that says, well, there's no procedure in the Criminal Procedure Act that permits for this. So the question that lingers is, on the basis of what dispensation should the request have been made by means of a notice of motion supported by a founding affidavit? Surely the submission cannot come from a party that says there's no procedure that articulates this in the Criminal Procedure Act. And indeed, the judgments that we rely on merely say you make a request when it is not clear. May I just, for the sake of completeness, say this, and I'll read from paragraph 11 of the Limpopo judgment. It says, leaving aside for the moment whether the question posed raised a proper question of law, the facts upon which the point of law was set to hinge were not set out in the state's application. So our colleague would expect us to ask Malady to reserve questions of law, but not set out the facts upon which those questions of law hinge. Because he says we should have first made the request for the reservation of questions of law.
No, it
and
doesn't say that.
Well, I may be mistaken. That's what I understood him to be saying. But may I then read further. The judgment says, what the state did was to summarize the evidence that was led without setting out the trial court's factual findings. It must be pointed out that the trial court's judgment in the discharge application is not a model of clarity. And we make that submission with respect that Malady's judgment, insofar as the factual findings are concerned, is not a model of clarity. We say that with respect. And then the SA says, if this is the reason the state was unable to set out the facts, it should have asked the trial court to clarify its findings of fact. It did not do that either. The trial court also had a duty to ensure that its factual findings underpinning the points of law were properly set out, but regrettable, it also did not do so. Despite this shortcoming, the trial court was content to reserve the question as one of law, falling within the ambit of this section. So
those judgments, in fact, deal with matters that are on appeal. And it is at that stage, when there is, according to those judgments, when there is an appeal and there is a point of law, then it can ask for clarification what those facts are that the court, based its finding on, that would be the subject matter of the appeal.
here, we have no factual findings at all, and I say that with respect. from the reading of the judgment.
Well, then isn't that then your mistake of law?
I'm willing to concede that it is, but if my lady says in response to the request that, well, because that is just one, there's various charges that they accused came before court to face. But if my lady says, well, I decline the request simply on the basis that what my lady has put to me is the answer, then I live with it. But it doesn't mean we are not within our rights to make the request that we made. It's a resolution. Then a submission was made that the state has not invoked, and I think it links with what I've just debated with the court. The state has not invoked section 319. We say, my lady, without knowing what the factual findings are, it is not possible for us to do so. I'm not going to deal with the other issues that, the suggestions that were made that the judgment is final. Of course, we accept that the judgment is final. I've debated with the court the question whether you're found to sufficient or not. And we submit that in providing what we ask you should provide, you're not found to sufficient. Thank you.
My ruling and the reasons therefore will be handed down in motion court on Tuesday.
As it pleases the court, Madam. Madam, may I ask that you excuse me from that, but I'll see to it that my attorney instructs junior counsel to note the reasons and the ruling. As it pleases.
Congratulations.
All right.